Hello friends, today I'm going to review the case of Mackin's. Before we moving to our topic, I want you to know what it means by similar fact evidence. Similar fact evidence is when the accused committed a similar offense in the past, showing that it is quite possible that they could have committed the offense again. In this case, John Mackin and Sarah Mackin are baby farmers. Have you ever heard about baby farming practice? Well, let me tell you, in the late 19th century, children being born out of wedlock means illegitimate children would commonly be given to couples that willing to take care for them, but in exchange for a small fee. What the Mackins did, they took the child in, but the money given to raise and care for the child was insufficient. The child was eventually found buried in a drain in the backyard of a neighboring property. The Mackins argued that they had taken in the child, but had given him back and did not know what happened afterwards. However, after small digging was done, it was found that there were in fact 12 babies buried in neighboring properties connected to the Mackins. The questions before the jury was not whether the Mackins had murdered the 12 children, but whether the Mackins' innocent explanation was improbable in consideration of the facts. At the end of the case, Mr. and Mrs. Mackins were charged with the murder of the child. Mr. Mackin suffered the death penalty by hanging, while Mrs. Mackin was given life imprisonment. Now let us move to the issue of the case. On the charge of the murder of the one child, could evidence of the bodies of the 12 babies buried in neighboring properties be admitted? This also means that whether similar fact evidence can be admitted. In this case, Lord Herschel reaffirmed the presumption that similar fact evidence would not normally be admitted. He went on to outline the exceptional circumstances in which this exclusionary principle could be overridden. Evidence of similar facts could not be admitted, merely because it seemed relevant to the count on the indictment, but only if it was both relevant and probative. You might be wondering on what is probative. It is actually the legal term that describes something that tends to demonstrate or prove something. For example, a weapon with the accused's fingerprints on it would be considered probative evidence at a trial. I personally do agree with the decision of the court. Similar facts could not be admitted merely because it seemed relevant to the previous offense, because such evidence, without doubt, it has prejudicial effect against the accused. It leads to premature judgment, and basically what it does, it takes away the chances for the accused to prove that he's not guilty. Therefore, I find that high emphasis must be given to probative value of the evidence. This means that probative value must outweigh the prejudicial effect. We can see this in the case of Bodman versus Director of Public Prosecutor. In Malaysia, we have Section 11, Subsection B, Section 14 and Section 15 of Malaysian Evidence Act, which provides grounds for admissibility of similar fact evidence. In short, I find it is a wise decision to admit the similar fact evidence based on its relevancy and probative value.